All rise. The Court of Appeals Division 1 is now in session.
Please be seated. We're here in our case 1 CV 17-0601, SIU versus Cavanagh. Each side will have 20 minutes to present their argument. Appellant, you may reserve any portion of the time for rebuttal, but you'll have to keep track of the time yourself. The clock at the podium for that purpose. We are recording the argument. In a couple of days, this argument will be available on our YouTube channel. Because we're recording it, when you come forward to argue, please identify your client and yourself so we can keep everything straight. We've read the briefs and the record. We've conferenced the case, so we're familiar with the issues. So when you begin your argument, just start out with the important things that you would like for us to know. Appellant, you may begin.
Thank you, Your Honor. My name is Gerald Maltz. My co-counsel is Stanley Feldman, and William Sue is the gentleman seated second in the first row. With the court's permission, we'd like to reserve 5 of our minutes for rebuttal. The record evidence of the case within the case includes concessions by Ms. Chang and her expert that Mr. Sue had separate property. It includes forensic accounting analysis by 2 separate accountants that the separate property was identifiable or traceable, and concluding that he had separate property.
Can I stop you there?
Yes.
Counsel, what is the nature of the malpractice that we're dealing with here?
The nature of the malpractice was the decision at the trial level to arbitrate rather than try the case in the Superior Court. And the consent of the client was secured by misinforming the client that by doing so, he would have all the rights that he would have in the Superior Court. That is, a right to a special master, a right to a Superior Court judge, as well as a right to a judicial review on the merits.
So the error is in the drafting of the arbitration agreement, or is it before that?
It's before that, and it's the drafting. It's before that because the client was misinformed that he would have a trial before a private arbitrator with all the equivalent rights of a special master or Superior Court judge. Then it was drafted to accomplish that, which cannot be accomplished under the Arbitration Act, because as soon as they invoked the Act, particularly the revised Act, they were precluded from changing any of the terms of the Act for vacating an award.
Well, you sort of there assume an answer to a question left open in the past appeal. Are you suggesting that there was a drafting error, or are you suggesting that no amount of the most beautiful drafting ever known could have achieved the goal?
The latter.
Okay, and I may agree with you that that's the way that the court would have gone, but the court didn't go that far in the earlier appeal, right?
It took a step in that direction because it said that in this case they didn't provide for review on the merits, so we don't have to reach the decision. But the court cited in a footnote the new provision in the revised act that says you cannot change the grounds for vacating an award. Arizona has never adopted the manifest disregard of the law rule. There's just no, you're just stuck with the award. You can't do anything about it.
I understand. So this leads me then to try and come up with a mental model of this case, and honestly it doesn't fit neatly into any of the boxes that we have. We can talk about trial malpractice, we can talk about appellate malpractice, but to me this doesn't seem to really relate to either. This is more transactional malpractice, right? There's advice given before the trial that leads to a choice of forum, and that's really what you're saying is the core of the malpractice.
Yes, with respect to the dismissed claims. We had other claims too, you're right.
Sure, no, I understand.
Right.
But,
that's exactly
But with
right.
respect to these, so what you have to establish then is that the choice of forum somehow disadvantaged your client. And would you agree with that?
Yes.
Okay. And so if that's the case, why? How do we address that by comparing arbitration to the Superior Court? I don't know that relitigating the underlying case really applies as a model in this situation.
It doesn't, and it doesn't fit into any of those boxes. It comes down to, as Judge Brammer opined, the client did not get informed consent. The arbitration provision, the stipulation, counsel for the other side focuses on the appeal to the Court of Appeals. But there's another provision that's really primary, and that is that the arbitrator will render an award in accordance with Title 25, the law. And what the client was told, and this is in the record and it's undisputed, particularly for summary judgment purposes, that basically we're devising a new forum. This arbitrator is a private arbitrator. He's going to be paid by us, but he's going to be a special master. And indeed, in pleadings before Judge Budoff, he's referred to as a special master. And as a special master, he's obliged to follow the law. He's obliged to adhere to the facts. And if he doesn't, a Superior Court judge can reverse him. In this case, they made that second mistake, thinking they could bypass the Superior Court, but they really can't bypass the Superior Court.
Okay. So accepting everything you just said is true, do you have to show that the result would have been different in court than in arbitration?
Yes.
Okay. And while you can undoubtedly argue, both sides can argue that the result would have been the same or it would have been different had things been done differently or had there been a different decision maker, how do you establish that the difference between arbitration and court is the key issue, and not the people do notices of change of judge all the time, presumably because they think they'll get a better result from some other judge. That's within the court, and it's all completely speculative. So how do we say that arbitration made a difference here?
Well, we have a number of items of evidence in addition to the opinion of Judge Brammer, in addition to the prior inconsistent statements of Cavanagh. They made it very clear that the arbitrator did not abide by the record, did not abide by the law, refused to even address the issue of the separate property of the Intel stock, and very significantly, it's the forensic accounting. Because how do you prove separate property other than through a forensic accounting? And the forensic accountants say it is identifiable. It should be enough to at least question the fact. And more towards your question, Judge Swan, a reasonable jury can conclude that a reasonable hypothetical judge or judicial forum would not have ignored concessions that there was separate property.
I've seen a lot, but I mean, how is this different from advising you just filed and you've got Judge Smith, and you have a discussion. Should we notice Judge Smith and the lawyer gives the client the advice, hey, Judge Smith is a really good judge. I think you've got a good shot. We're not going to notice Judge Smith. And Judge Smith turns out to do an absolutely horrendous job, which, under the standard of review, which, as you know, is deferential in family court, the Court of Appeals declines to do anything about. Is that the same case?
No, because the arbitrator is not. The reason you cannot review an arbitrator's award for errors of fact in the law is because he doesn't have to follow the law, and he doesn't have to apply the facts in the record. The arbitrator has the power to do anything that he determines is just and reasonable, irrespective of the record, as long as it's an issue submitted to him.
Is the point you just made critical to your case?
Absolutely.
Okay. Then can you show me where? I mean, I acknowledge that arbitrators' decisions are unreviewable, and I'm no adherent to this view that arbitration is the superior means of decision making by any means. But I also don't see in the Act anything that says the arbitrator doesn't have to follow the law.
Yes, there is in the Act, and that is the grounds for setting forth, for vacating an award. It's fraud, it's failure to give a continuance, and I think there's two others.
Well, but does the Court of Appeals have to follow the law? Because the Supreme Court has long declared that it is not a court of error. If the Supreme Court violates the law, or if the Court of Appeals neglects to follow the law, the Supreme Court may not take the case. Does that mean we don't have to follow the law, or does that just mean that the system of review is somehow lacking?
The Superior Court has to follow the law. An arbitrator does not have to follow the law. And if you look at the federal arbitration cases, there are, and if you look at states that don't have the revised act, there is case law to the effect that one of the unstated grounds for setting aside an award is manifest disregard of the law. Arizona rejected that, never accepted that. Right. And then the revised act goes further and says you can't change it. You can't change the grounds for vacating an award. So unless you have fraud, you cannot, or the other statutory grounds, you cannot set aside an award, which means an arbitrator could do exactly what the arbitrator did in this case, and a Superior Court judge cannot do. Ignore stipulations, refuse to award separate property where it's conceded, and make substantial errors of law without a remedy. There's always a remedy for the Superior Court doing that.
But not always a remedy for the Court of Appeals. I'm not suggesting that we wouldn't follow the law. I view us all as having an obligation to follow the law, but there's not always a remedy when the court errs.
Right, but if you get to the point, if you get past what the judge, the Superior Court judge did in this court, which he said, he did not say this was appellate level malpractice. We've never alleged appellate malpractice. He said included in this is the fact that there was no judicial review. So it's akin to appellate level malpractice. I'm going to take the issue away from the jury. And I'm going to find, and I do find, that there is no evidence that Judge Sanders, the Superior Court judge, would have ruled any differently than the arbitrator. Compare that to how the judge handled the remaining claim, where Judge Warner gave the exact same causation opinion as Judge Brammer did with respect to arbitration, which was the client was misinformed, the client was damaged, and as a result of the damage, Judge Kiley held a reasonable jury could find that we would have fared better in Superior Court than he did in arbitration. That is the correct analysis. Why it wasn't applied to the arbitration failures, because but for the malpractice, we would have been in Superior Court. It's inherently inconsistent. So we do have a situation where there is a substantial difference between a non-judicial forum that's not obliged to follow the law because there's no remedy if it doesn't, and a judicial forum that is obliged, and not only is there a remedy, but in my almost 50 years experience, I've never seen a judge in the Superior Court reject a stipulation.
Judge Budoff, of course, was a longtime family judge.
He was.
And did he give any indication that he felt free to ignore the law because he was asserting his country?
Not in that sense, but as we briefed, all during the arbitration, and it's particularly set forth in Mr. Sue's declaration, which was Exhibit 5 in opposition. I think it's 172 in the index of record. All through that, Budoff said, well, I'm not final here. Either of you are going to go to the Court of Appeals. I'm not final. Now, whatever I rule here is not going to be final. This is round one. Essentially what he was saying. I mean, when I was deposing Mr. Cavanagh's attorney, I asked if he ever read the book Thinking Fast and Slow by Daniel Kahneman. Daniel Kahneman was that Nobel laureate whose specialty is decision making, and he has a concept called a default decision. And that's really what happened here, because Judge Budoff was saying, whatever I do is not going to be final. So I'm going to basically make a default decision. Community property, everything's community property. If I'm wrong, the Court of Appeals is going to straighten it out. The only problem is there was no jurisdiction to straighten out an erroneous arbitration award. I see I'm down to 4 minutes and 45 seconds.
Thank you, counsel.
Thank you.
Good morning, Your Honors. Eileen Gilbride for the Cavanagh defendants. With me at counsel table is Gary Linder, trial counsel.
Counsel, do you agree on what the nature of the alleged malpractice is?
You know, what we briefed, what was raised in the opening brief and what was raised below, the issue was the decision to arbitrate deprived Mr. Sue of an appeal on the merits. That's what the issue they raised, and that's the issue that we responded to in our briefs. That's what I understood the issue to be. The decision to arbitrate deprived Mr. Sue of an appeal on the merits. That's what I understand the issue to be.
And that doesn't quite seem to be the issue as it's presented today.
What I was hearing is something different. I'm not quite sure, honestly, what I was hearing. But I think the issue that we briefed was he deprived, if he was deprived of an appeal on the merits, did that damage him?
Well, what we heard in the earlier argument, I have to say, makes sense to me as a mental construct. I'm not projecting a view either way, but it makes sense as a mental construct because I don't see how we litigate a case within a case to determine what the review would have done to something that was unreviewable. Right? I mean, that's really the problem. Is you say, well, this deprived us of an appeal on the merits. Well, there is no appeal on the merits.
Well, then he definitely had no damage.
Right. You could say, well,
I mean,
he lost something that
he never had in the first place.
But then that goes to the next question: why did he lose it? Was he given advice that led him to waive a right under a misexpectation?
Regardless, I mean, that goes to the breach issue, but it doesn't address the proximate cause. You still have to he has to prove that whatever the alleged breach was caused him damage. And if he never had an appeal on the merits, he didn't lose anything. And if he's claiming...
Well, he had an appeal on the merits originally, right?
If
because
he
had the right to come to court.
Right.
And so that's an appeal on the merits,
and
which
yet,
he then waived based on advice he received.
And yet, I mean, the record is clear that he would have lost that appeal on the merits. And so
Which appeal on the merits?
From Chang versus Sue.
Okay, so,
Because-
so if we assume that a superior court committed the same alleged errors as the arbitrator, then
Right.
the Court of Appeals wouldn't have
Reversed. Correct,
Okay,
because
but what is the authority for even doing that? For assuming that one judge is going to commit the same error as another judge? Don't we assume that the judge is going to get it right?
well, you have to look at, you don't assume anything. You look at the record as it was made during the arbitration or the trial or
Well,
at
that's
the
part
lower
of the
court.
problem with arbitration is there isn't the same record that we have in superior court. So is the model that you were prepared to discuss one where we just say, assume that Judge Budoff was a judge again for however long it took to arbitrate this case, and not an arbitrator, and then assume it went to the Court of Appeals? What would have happened? Is that
Well,
the idea?
Well, but they haven't alleged any legal error that he made. What they have alleged is that, or that what they've argued in their briefs is that their evidence was more persuasive than Ms. Chang's evidence, and that in this case, someone should decide that it was his evidence was more persuasive, and we're not going to do that here. He already got a chance to persuade the arbiter. He didn't persuade the arbiter. He did his best. Ms. Chang put on her evidence. It conflicted. Judge Budoff made his decision based on conflicting evidence. He determined the credibility of the witnesses, and he weighed the evidence, and he came out with his findings of fact. As long as there's evidence to support those findings, he wouldn't.
Sure, that's just a general discussion of the standard of review in
Right.
appeals. But I guess what I'm trying to go behind that and see what hypothetical construct we're really applying that to. It sounds like you're saying if we pretend that Judge Budoff was operating in a court, then the Court of Appeals, under its standard of review, wouldn't have reversed, right?
Well, you could put it that way, but they haven't given you any evidence that Judge Budoff was doing anything differently than a Superior Court judge would
You're
do.
down the road. I'm
Oh, sorry.
Early stages. Here.
Okay.
Early stages.
Back up.
If we're going to ask, if you're asking the court to do something, under that theory, you're asking the court to pretend that the arbitration was a court proceeding, and that the same result obtained in the court proceeding.
Okay.
Right? I just
Well-
want to make sure I'm understanding.
Well, you can either do it that way, or you can say if the agreement to arbitrate had preserved the appeal on the merits, which was what the parties had agreed to.
Right.
If the arbitration agreement, the agreement to arbitrate, had preserved the appeal on the merits, and they had gone up to the Court of Appeals and skipped over the Superior Court, which is what the arbitration agreement said, and this court had reviewed it on the merits, what would have happened? What would a reasonable court have done? It would have looked at the record as it was made before Judge Budoff, seen that the evidence conflicted. Judge Budoff's decision was based on substantial evidence, and it would not have reversed. And because that is what the Court of Appeals in Chang versus Sue said.
So we still have two alternate models, and I'm sorry to be so basic, but this is an unusual case. I've never seen a forum selection malpractice case before, and so I really want to make sure that we're all talking apples to apples.
Okay.
So that's one way to look at it. What you've described
Yeah.
is, let's assume for a moment that the advice Mr. Sue was given was absolutely correct, and it went to appeal. There would have been no difference. That's
Correct.
Model 1.
Correct.
Model 2 is different, though, which is to say, if Mr. Sue had known that the advice was incorrect, he never would have been there in the first place.
Okay. And he would have gone to Superior Court.
Right.
Right?
And then we're stuck with asking what would have happened in Superior Court, and that's where my understanding sort of crumbles, because I don't know what happens in Superior Court.
Right. Well, plaintiff hasn't suggested that the record would be different in Superior Court. They haven't suggested that.
Well, I think he has. I think he suggested that there were stipulations that would have been honored.
Right, and that's incorrect, because what they have argued is that, just a second, is that Ms. Chang's expert conceded a bunch of things, or that Ms. Chang's lawyer conceded a bunch of things, and that's just not correct, because the record is actually, it conflicts on that point. In other words, what they've said in their briefs is that Ms. Chang's expert conceded that a bunch of accounts were sole and separate. She didn't. And if you look at day 3, that the arbitration, day 3, page 20, day 2, page 115 to 135, and 157 to 158, you will see where Ms. Chang's expert says, no, there was community property in the collateral account and in the 739. She didn't concede anything. So they haven't really come up with something that they would have done in Superior Court that wasn't already done in the arbitration. They haven't brought forth evidence that there was some different record that they would have done, or some different evidence they would have put on that would have made the trial court process come out differently.
Okay, well, I think you've defined the issue well, and I'm sure we'll hear rejoinder on that.
Okay.
But I would like to know, though, is the allegation of malpractice as presented here today in an argument, whether, whatever we might think about the merits of that allegation, is that the allegation that has been made all along up until this point?
The way I understand their arguments all along is twofold. One, that Mr. Sue was denied the merits-based appeal, and our argument has been he wouldn't have won a merits-based appeal, so no causation. And the second one was the agreement to go to arbitration instead of Superior Court, and again, there's no evidence that anything that he would have won his case if he had presented it in Superior Court instead of, or with a different arbitrator. I mean, you can speculate. I mean, it's all he can do is speculate, but there's no evidence, there's no expert, and I'm not even sure that you could have an expert come and say he would be speculating or she would be speculating as well.
Well, what if you had one of our well-known arbitrators in town as the expert say, yeah, I would have reached a different decision?
I mean, I suppose that isn't this record, but on the other hand, I mean, an arbitrator is entitled, doesn't mean that Judge Budoff did anything wrong, because he's entitled to find his credibility and find the facts the way he finds them. Whether somebody else would have found something else doesn't mean that they wouldn't have. They would have, they wouldn't have. I mean, it's all speculative.
So if you had a judge who just retired from the family court bench last Friday say, oh, I would have come out completely differently, your position would be that's irrelevant.
It is irrelevant because, again, it's like the example of, well, I would have noticed this judge or noticed that judge. You can't determine what would have happened. It's all speculative of what would have happened if he had gone to a Superior Court judge.
So, if the malpractice is the advice
to arbitrate,
yes,
yeah,
then he would have to prove that he would have won in Superior Court.
Correct.
And I'm having a hard time getting my mind around how anyone could do
I agree.
that.
I agree with you completely, and it's what I just tried to express, and maybe not very well. I'm not sure how you do that, and maybe as Judge Swan was saying, you have a recently retired judge come in and say, well, I would have done it differently, but that doesn't prove that I mean, I suppose, and then we could have had an expert come in and say, I would have done the same thing. And then what? Is that a question of fact? I mean,
To be fair to Mr. Maltz, I think what he's saying is this isn't up to the vicissitudes of individuals. This is a question of did we follow the law or not. And in court, we follow laws, and in arbitration, it's the Wild West.
that's all very well and good, but he has not given you one case that says Judge Budoff made an error of law or that he didn't follow the law.
I think his point is slightly more abstract, which is Judge Budoff was not bound by the law. And let's assume for the moment that there were some errors of law. Just indulge me in that. I argue it.
Errors of law?
Yeah, let's
Okay.
assume that
Is it
Judge
different
Budoff
case?
made some errors of law. I know.
Okay.
But just to get us to the next level.
Okay.
The argument is Judge Budoff doesn't care if he made errors of law because he doesn't have to follow the law. This is arbitration, and law is for those silly courts.
Okay.
Do you, if that's the model, and I'm not sure that I agree with that model, but it's a critical component of their argument, would you agree that there is perhaps less fidelity to the law required in arbitration than there is in court?
I don't think it matters. Unless he can prove that Judge Budoff made an error of law, it doesn't matter what he was, bound to follow or not bound to follow.
Well, that's why I asked you to indulge me in the assumption, because I know I know as sure as I sit here that I'm going to hear about an alleged error of law that Judge Budoff made in about 5 minutes and 53 seconds. So once we hear what that is, indulge me, and then let's talk about the system.
Okay, well, if Judge Budoff had made an error of law, if that you're asking me to assume that, even though they haven't mentioned any error of law, in fact, in their reply brief, page 11, they say there's no error of law here. They actually say that, but I'll indulge you and say if there was an error of law where Judge Budoff had done something improper, illegal, for lack of a better word, then I suppose he could prove, or there would be an issue as to whether the Court of Appeals would have reversed on that, and that he would have won on the merits. Is that what you're getting at?
Kind of, but then we get to major and minor errors of law, right? If the major error of law would be Judge Budoff says, I've been doing community property law for decades, and I'm just tired of it. We're not doing that anymore in this arbitration. That would be a pretty clear error of law, right? And we could probably hypothesize that an appellate court would have reversed if that had happened in court.
Okay.
If, on the other hand, the error of law relates to the admission of evidence or the rejection of some evidence,
that's an
such
abuse.
that it would trigger an abuse of discretion standard.
Right.
That's
not going to get him there.
Different kettle of fish.
Yes.
So when you say there were no errors of law, you're talking about
the former
de novo major
yes.
errors of law.
Yes.
Okay.
Yes.
Thank
Exactly
you.
so.
All right.
If the alleged error is a lack of advice and the plaintiff has to prove that they would have won in superior court, those are all kinds of factual questions. Would he be entitled to try? However, inconceivable we might think at the moment about that.
I suppose if he had come forward with some evidence that he would have won in superior court, he might have raised a fact question, but he did not come forward with any evidence. I think he mentioned that, Mr. Maltz mentioned that Judge Brammer opined that. He did not. He did not opine that Mr. Sue would have won in superior court. Neither Judge Brammer nor Judge Warner opined that. It's not anywhere in the record. And they both said neither, well, that goes to the appeal issue, neither were asked to review the record or determine whether there would have been a reversal on the merits of the appeal. So neither one of them said that. And I think I heard him say that. If there are no more questions on the merits, I just wanted to make one comment about the supplemental citation of authority that was filed last week. Mr. Maltz came up with two cases, Kern versus Kern and Razor versus Northwest. The only relevant thing about Kern versus Kern is that in that case, after the family court found that 88% of the Disney stock was husband's sole and separate property, this court reviewed that finding for clear error. It did not review it de novo, and that is the standard of review that Mr. Maltz was advocating for. His own case undermines that argument completely. Kern is also factually inapposite because there the court specifically stated that there was no commingling issue, and that's at paragraph 18, and of course this case is entirely about commingling. And on Razor versus Northwest, in that case, the nurse had only read part of the medical records and not all of them, and the court said that was appropriate for cross-examination. It went to weight and not admissibility. Here, Judge Brammer admitted that he hadn't read the arbitration record, he hadn't been asked to read the arbitration record, and he hadn't been asked to opine whether Mr. Sue would have, been successful on appeal or not. So it's an entirely different, this is a foundation case, that was a weight case.
Just backing up for a moment, would it be your position that any amount of drafting perfection could have achieved the desired appellate result?
I'm not sure about that. I personally tend to agree that the arbitration rules prohibit an appeal on the merits from an arbitration, but I happen to know that it was a well-known practice, and it was done quite a bit among family lawyers to make these kinds of agreements. So whether it was, a breach or not a breach, I think would be an issue that's up for debate. I don't think this court or the Supreme Court has made that ruling yet, whether or not you can actually appeal from an arbitration. Whether parties could agree to get around the no appeal on the merits. I'm not sure.
Okay, and I'm pretty dubious that they could.
Yeah.
But
I also know it was the practice for a long time. I don't know if they still do.
Okay, so would you define the issue on liability then as the quality of drafting or the conceptual viability?
It's not the quality of drafting. They've never said that it's the quality of drafting at all. It was the advice to arbitrate. The advice to arbitrate, and that you would have an appeal on the merits. That was the nut, if you.
And is your view before us that conception of the case was the advice rather than the loss of the appeal?
Yes.
That really wasn't presented below and isn't properly before us?
I think that version of the case, that view of the issue, was what has been presented and what has been argued in the briefs. You told me that I would have an appeal on the merits from arbitration, and I didn't get it. And that's, I think, is what the nut of their case is.
So the malpractice, the alleged malpractice is the bad advice from the get-go.
I think that's what they're saying, yeah. That's what they have argued all along.
I'm going to ask Mr. Maltz about this, so I might as well give you a chance to address it before you sit down. I assume, and tell me if this is not in the record and I will simply desist, but I assume that there was some reason given for the advice to arbitrate in the first place. Not just that we can do this circuitous route to an appeal, which already existed in Superior Court, but that there was some benefit to arbitration. Is there anything like that in the record? Our expert, Angie Hallier, testified that it was a good idea because it was the only way, really the only viable way of getting anybody to buy his argument that he hadn't transmuted all of his sole and separate. Well,
and the only other
expert, I'm less interested in what your expert says than I am in what
the actual record.
The advice was. Yeah, I mean, I'm sure they didn't hire an expert to say you got to arbitrate.
I believe I believe the decision was made jointly because they knew they would get a much longer, they wouldn't be limited to the 1 or 2 days that you get in Superior Court, but they would have the opportunity to present their 9 days of, it's a very complicated case, and I believe that's in the record.
That's what I expected.
Yeah.
Okay.
All right. Thank you.
Thank you, counsel.
Judge Swan, in answer to your last question, the arbitration record doesn't have all of that.
I'm not asking about the arbitration record. I'm asking about the malpractice case
Right.
record.
I misspoke. The summary judgment record doesn't have that. What's in the summary judgment record, most of Angie Hallier's opinions are not part of the summary judgment record. What's in the summary judgment record is the declaration of Mr. Sue, who was told that family court is a hardship assignment and he'd be better off with this non-existent device of an arbitrator who would have all the powers of a special master. And that is a non-existent concept, and that's what he was persuaded to do.
But is it not the case, it is, I think, fairly well known that the time allowed for trial in Maricopa County Family Court is highly constrained, often.
Right.
And that a day-long trial is often considered a luxury, which surprises some people. Is it not the case that part of the advice at issue here was you can have more time to fully present your case if you do it outside of the normal judicial system?
Let me quote Robert Sisko, and it's in our briefs, their co-counsel on appeal. Why in the world didn't you go with a special master? You could have had all the time you wanted with a special master, and you would have had all the protections of a Superior Court trial. That's the answer to that.
Well,
They had an option.
I'm not sure that I'm not sure that I agree with Mr.
Okay.
Sisko. Special masters give you yet another layer of deferential review, but that doesn't answer my question, which was the time available in arbitration a part of the inducement to do this? The inducement to arbitrate could not have been that there would be an appeal. There must have been some other reason to do this.
The answer was that they thought they needed 5 days originally, and that was an issue. And it turned out to be 9 days. They had Craig Reimuth on the stand for 3 days. It was a total disaster.
Well, you can call that a disaster, or you can call it a success in terms of the forum, because it achieved the goals of the forum selection by giving more
Right.
time. Right? But let me ask you now,
Yeah.
just before it slips my mind, and I promised I would, are you able to point to any errors that happen at the arbitration that are of that de novo magnitude?
Yes. And basically here I'm echoing what Cavanagh said in its appeal in Chang versus Sue. Cavanagh filed a 30-20 motion pointing out all the errors of law and fact in the ruling of the arbitrator. Numerous errors of fact not supported by the record. They went item by item by item, just things that were totally invented. And as far as the legal issues, one is that the arbitrator was wrong in applying the dollar-for-dollar standard of tracing. He was overruled in the Conoy case for doing the same thing. He did it in this case, and dollar-for-dollar tracing in a stock account where your stock is owned in cyberspace, you put $1 in at the beginning, and that same dollar or blue nickel has to appear at the end. Phil Gerard argued this eloquently in the Chang versus Sue appeal. Unfortunately, there was no review of the merits. In the summary judgment record, we have his argument, we have his brief. Also, another major error of law was the decision that after the accountants directly traced all of the stock, they made a proportional allocation between the separate property component and the community property component.
How is that illegal as opposed to an expert methodological error?
It's because in the arbitration award it says that's not Arizona law. You can't use proportional allocation in Arizona law. It said, and
Have you cited a case
Yes, yes. And basically what I did is I cited their briefs in Chang versus Sue, which cited all the cases. Stevenson, Batiste, the statute, it goes on and on and on. In the current case, they cite the Conklin case. No, I think I'm mispronouncing it. The Cockrell case. That's another proportionate allegation. The other thing is he said Arizona law does not contemplate equity. And the cases that are cited by Cavanagh and Chang versus Sue, and we relate to it, says equity is the fundamental reason for the division of property in the state of Arizona. Let me correct counsel on a couple of inadvertent misstatements. Judge first of all, we have always alleged what we alleged here, and it's in our opening briefs. We cite the argument to the Superior Court, and they acknowledge we're talking about Superior Court error. It's also acknowledged by Cavanagh in its reply on summary judgment. Its reply on summary judgment says, okay, so this is a Superior Court error. Doesn't make any difference. There's still zero evidence of causation. The evidence of causation was not only the stipulations as to property, separate property, and we cite that. It was, she never withdrew that concession, and we cite the page where the expert for Chang says, I knew that all of his Intel stock, the remaining Intel stock, over 200,000 shares, was his separate property. She came to that conclusion. Finally, Judge Brammer says, and I'm reading from page 68 of the disclosure statement, which is the index of record 171, Exhibit 1, which he attests to in his declaration. He says, defendant was retained and paid to protect Mr. Sue's separate property rights in accordance with Title 25, and also to preserve his right to judicial review on the merits. But it failed to do so, falling below the standard of care for attorneys similarly situated. The result is that Mr. Sue lost a substantial chance of success, both in the Superior Court and the Court of Appeals.
Thank you, counsel. We appreciate your argument.
Thank you, Judge.
Today, we'll take this matter under advisement, and we'll issue a decision in due course. We stand adjourned.